Let's talk about the biggest mistakes that are made by people when it comes to trust, and in particular, when the trust is being set up, because these mistakes have an effect on the trust normally after it's been or has been set up. So, without further ado, let's get to the discussion. For the people that are new here, hi, welcome. My name is Yolanda Mnyengeza. I'm an attorney and a director at a law firm here in Johannesburg, and we mainly specialize in estate planning, trust, and other stuff. Right, so let's not waste any time and get to the discussion. So, what is that first mistake that people make when they're setting up a trust? Well, the first one is in utilizing other people's trust deeds or not utilizing a trust deed that is tailor-made for them. What is a trust deed? Remember, when you're setting up a trust, one of the first things that happens is that you're going to sit down with a legal practitioner who's going to establish exactly what you want to use this trust for, the terms and conditions. What do you have in mind? What are you going to place there for how long? You know, how do people benefit, etc. And then after this discussion, they're going to do what? They're going to draft what we call a trust deed. It's more like a contract, right? So this document is going to be the governing document of this entity. So the people running this entity are going to be strictly guided by what? That document. It becomes like a Bible of that particular entity. So even the future trustees are going to be bound by what? By that document. Now, a lot of people, because they want to escape paying, certain costs, they will go to people who are not specialized or not specializing in this industry and say, listen, help me set this thing up. And then they will not really get what? Get that particular trust deed drafted in accordance to their needs. Or sometimes what they will do is that they will take another person's trust deed and just go to the master because they think that it works that way, and then get the surprise of their life when the trust is registered. And one of the most famous things that often happens, right, there's a few, but I'll talk about just one, is that when they do this, they tend to nominate or appoint beneficiaries that are not necessarily suitable for the type of trust that they're establishing. Remember, families are different. How people will use a trust is different. What they're going to place there is different. What they will have in the future and what they have now, totally different. That's why a trust has to be what? Tailor-made, and the terms and conditions tailor-made for your own trust. Now, what happens is that when these people take a trust deed that belongs to another family, they would then appoint beneficiaries that are not suitable for that trust, right? And confer a right on that beneficiary or those beneficiaries that the trust cannot afford, not in the next 10 years or 50 years for that matter. For example, a person would confer, let's say that family was saying to their beneficiaries, they're going to get 10,000 Rand a month. Now, by taking that document, now they are also binding their beneficiaries and saying that this is the benefit you're going to get as a beneficiary on a monthly basis, but there's no money in their own trust. And in some instances, the only thing that they have is a property. Do you know what happens when this kind of situation, unravels? What happens is that you'll find beneficiaries suing trustees. What are they suing them for? They're actually suing them for what they are entitled to. The deed makes it clear what they're entitled to. They're entitled to 10,000. Now, they have not gotten their 10,000, so they want their 10,000. So then what do? They sue the trustees. We want our money. The deed says and makes it clear that we're meant to benefit right now and we're meant to get this amount of money. You know what then happens in most instances? The trustees will start selling the properties inside so that they can give these guys 10,000 Rand. And then eventually the assets in that trust will come, to an end, because that was not the type of trust you were establishing. That was a type of trust that was suitable for another family. But because you never wanted to pay for the service of getting this drafted, Now you've got a situation where the trust is losing assets that you wanted to preserve and you wanted to protect. Because why? You have now conferred a right on people who never were meant to get that right now. Do you get what I'm saying? So that's the first mistake a lot of people make when it comes to setting up trusts. Let's go to the second one. And the second mistake that people make is in the appointment of their trustees. And this one becomes a major issue in the future. Again, if you don't speak to someone who's going to give you proper advice and guidance, you're going to miss this one, right? For instance, some people would set up a trust and become the trustee, the founder, the beneficiary, and have nobody else a part of that trust as a trustee. They will have full control. And in their minds, they would be thinking that I've got an entity that is called a trust. And in this trust, I've got my assets protected and preserved. If any creditor wants to sue me, they can't win. If any divorce comes my way, they can't win because I've moved my assets in that trust. But then again, they forget they are still fully in control of the assets. What is the danger of this? See, when you are a founder, a beneficiary, and also the only trustee, it means that that is a second you, because you have full control of that entity, just like you have full control of yourself. So in these instances, the courts normally will not separate the two. As much as the purpose of establishing a trust is that an entity separate from you exists, now because you are in charge of every avenue, this is not separate from you. It is seen as an extension of you. What then is the result of this mistake? What the result is that you'd find that the creditor, if you, for instance, can't pay them, they'll sue you, obviously, right? To get a property of yours that can be sold. Now, you'll be thinking you're safe because you've placed those properties in the trust. Rest assured, those creditors will apply so that those things that you have hidden in that trust also be considered as your as your assets, as much as they are under a trust. And you know what will happen? In most instances, the judge or a magistrate will say yes because of the way in which you are handling these assets. That's a loss. You thought you were protecting yourself, but because you want to hold every avenue on your own and have full control, you jeopardize the safety of that entity. Also, when it comes to divorce, I want you to Google the amount of cases where people have had their trusts compromised. And one of the things that you'll notice that the main reason that the court agreed that the things that are placed in a trust also be looked into is because of the fact that this person who was the founder of this trust was also the same person who was the trustee and also a beneficiary. And in all of these roles, they were fully on their own and in control. And because of that, then the court said, you know what, there's no separation between these two. In fact, this is just an extension of you. And therefore, the assets in that trust must also be considered as part of the divorce. This is what jeopardizes your trust. And this is a mistake a lot of people make. Let's go to the third one. Now, another mistake, which is the last one we're going to talk about here, that people make when they're setting up a trust, is that they're not necessarily considering the type of trust that's going to be suitable for them and their family, right? A person hears about a certain type of trust and they think, this one is good for me. It is critical, it is crucial for you to have a sit-down discussion with your legal practitioner so that they can thresh out for you the different types of trusts, right? And then from that, you can then make a determination after also they've heard what you want and what your intention is and what you probably want to place there, right? Because if you don't, you're going to choose a trust that might deprive your family of the necessary things that they will need when something happens to you, right? A trust is that vehicle that we set up to ensure that, number one, we don't lose most of the money that we have to taxes. Number two, that our families are fully protected and that they continue to benefit from everything that we have. And also to serve as a shield so that assets are protected and easily accessed, right? Because we know, for instance, what administration does. It makes it difficult for people to get access to properties on time. Makes it difficult for people, for instance, to access the necessary funds for your family to be easily taken care of. So this is where then a trust comes in. For example, one of the things we see, or I have seen, is people setting up, for instance, things like a testamentary trust, whereas they could be setting up an inter vivos trust. Why do they do this? Number one, it's because they don't have the necessary information, or at the time when they were setting up or thinking about this, they never had the necessary information that was suitable for them to make an informed decision. And number two, there was fear instilled in them that if you set up an inter vivos trust, you will pay high amount of taxes, right? But then a lot of people who often say this don't even know how the tax operates when it comes to trusts. And this is the biggest downfall for a lot of people, because you'd find that there wasn't even going to be much tax implications if this person had set up an inter vivos trust and structured it in a certain way. Because a trust, whatever tax is paid is determined by what is happening and the activities happening in a trust. And someone who doesn't understand this will get scared when they hear a trust is taxed at 45%, right? So it's important for you to get the necessary information, sit down with someone, understand this and how it works so that you can make an informed decision for your family. Because now what people say is, okay, for me, I'm going to set up a testamentary trust. But then they have a child that's still going to school. They are still paying for, let's say, levies and rates wherever it is that they're staying, and they're still responsible for a lot of things, right? Forgetting that when they set up this trust, the first thing that still needs to happen before anyone can get access to the money is that administration has to take place. And administration, if you've watched our videos, takes a bit of time. And after the administration process, then a trust has to be established. This takes its own time. After the trust has been established, whatever it is now that was in your personal name is now being moved to the trust, right? And this comes at a cost. Now, when everything gets there, that's when people or your family starts benefiting from it. So in some instances, this is not necessary for some people. But because they've heard about, this 45%, then they let me steer clear and just set up a testamentary trust. But then a testamentary ends up being the expensive route instead of what? An inter vivos trust. Like I said, sit down with someone. Let them explain to you how this operates, right? Because if someone specializes in this industry, they will know how this is actually calculated. On that note, we will see you next time. We hope that this was helpful. Listen, if you found it helpful, share it, like it, come back, because we have a lot of these discussions. We'll see you next time.